यूपी तो जजेस जिला पार्टी को जिला नाम तो कौन है
मम्मा ने कनेक्ट क्यों करे जो मम्मा
is not afford. એટલે એ લોકો બધાને મ્યુટ કર્યા છે. I hope I can be heard. Are you able to hear me?
Yes, sir, you are clear.
Okay. What does the doctrine of force majeure or act of God or the principle of frustration of contract do under the Contract Act? Let us brush up section 56. It says that when it becomes impossible to perform the contract or it becomes illegal to perform the contract, it becomes void. The supervening impossibility renders the contract void. It means that both the parties are discharged from further obligations under the contract. The contract comes to an end. The question which arises here is whether this is the solution that the commercial communities either want or can really afford. The doctrine of frustration is offering, if I may use the words, stark binaries between keeping the contract alive or killing the contract. If the contract is kept alive and if it is enforced in its full rigor, the parties will suffer because of these difficult times. If the contract is killed, then also the parties suffer and it doesn't do complete justice between the parties. How this happens, I want to illustrate by a case of a commercial lease of a premises, say for a period of 9 years. Such kind of contracts are not uncommon. We encounter them in our daily lives. The lawyers frequently come across commercial contracts with long-term durations. They may be lease, they may be toll road collections, there may be various other types of construction contracts whose duration is long. Take a very simple case of a commercial lease of a showroom, say for a period of 9 years, with a lock-in of maybe 3 years or 5 years, depending upon what the parties have chosen. Now, in such type of commercial leases, the predominant trend is that the parties lease only the bare superstructure, and the furnishing has been done by the tenants. The whole furnishing of the leased premises is at a considerable cost, and in many cases, such cost runs into crores of rupees. Take, for example, a showroom where the garments or the apparels or the jewelry is sold. Now, these showrooms are exquisitely furnished by the tenants. That furniture cost runs into crores of rupees. If these contracts are voided by applying the doctrine of frustration, it only means that the tenant has to walk out of the premises and dismantle the furniture which it has so painstakingly installed after incurring considerable costs. How does it help the tenants to void the contract in such cases? Therefore, the doctrine of frustration, with its resultant effect of voiding the contract, is an extreme solution. If you will examine the provisions of the Indian Contract Act, either section 31, 32 dealing with contingencies or section 56 dealing with frustration, we will notice that the Contract Act as a statutory regime deals with two extremes, either keeping the contract alive as it is or killing the contract completely by voiding it and freeing the parties from further performance of their obligations in future. However, there is a third possibility, and it is to that third possibility that I wish to take all of you there. I want to show that there is no need to enforce the contract as it is. There is also no need to kill the contract completely. But there is a case for equitable intervention in the performance of the contract may be required to suspend the operation of the contract for the duration of the pandemic. For this purpose, there are instances in Indian legislation. I take you to section 22 of the SICA Act. All of you are aware that now the act is repealed. However, section 22 of the SICA Act provided for a power vested in the board constituted under the act to make a declaration that the operation of the contracts and agreements is suspended. If such declaration is made, the whole contract comes to a standstill. The contract does not get voided, it just comes to a standstill. There was an old legislation enacted by the erstwhile Bombay state, the Bombay Relief Undertaking Act 1958. I take you to section 4 of the act. It also spoke of suspending the performance of the contractual obligations. So there are statutory precedents in India when the power has been given either to the executive, just in the case of Bombay Relief Undertaking Act, or to the Board for Industrial and Financial Reconstruction constituted under SICA, to suspend the operations of the contract. The question which arises is, why cannot India, that is the Indian government or the state governments, bring a similar legislation giving reliefs to all the parties who suffer from the extreme economic hardship resulting from this pandemic? For this purpose now, I want you to take a look at the Singapore model, the Australian model, and the United Kingdom model. How these countries have come up with very swift response to such pandemic and its disastrous impact on the commercial communities. The legislations which these countries have brought are commendable efforts at prompt relief to commercial communities. Firstly, I take you to the Singapore model. Singapore has enacted what they call a legislation known as COVID-19 Temporary Measures Act 2020. The scheme of the law is to identify certain contracts which require the relief. The act defines applicable contracts as scheduled contracts. There is a list of contracts included in the schedule which are eligible for seeking relief. I will not read the whole list, but it includes, for example, the commercial tenancies, the residential tenancies, a construction contract, a hire purchase agreement, a performance bond or a bank guarantee, or a contract giving loan. I will not touch the loan part because the Reserve Bank of India has issued a moratorium, and the same is, in a way, in the same direction of partially alleviating the current hardship. After identifying the contracts, what the Singapore legislation does is to give it a retroactive effect. This legislation is made applicable to all the specified or scheduled contracts which are entered into prior to 24th of March 2020. Therefore, all those contracts which were made before the pandemic hit us are eligible for relief. The Act provides the basic condition for such specified contracts to be eligible for protection. It says that the party must be unable to perform its contractual obligation to a material extent on account of the effect of the pandemic. If this condition is not fulfilled, the contracts are not eligible for relief. Now, if the contracts fulfill such conditions, the Act provides the modalities for granting the relief. How does the Act work? If the contract falls within the category of specified contracts, and if the condition is fulfilled, the party who suffers from such incapacity or hardship is required to give a notice to the other party about such hardship and its intention to seek the relief under the Act. This is the trigger point of the Statute of Singapore. A party in difficulty will give a notice to the other party. The interesting part now is that no burden is cast on the suffering party. The burden is cast on the recipient party if it wishes to contest the claim made under the Act. The party which wishes to contest is required to make a reference to special assessors appointed under the Act for the purpose of determining whether such claim is valid or not, and whether the claim is fulfilling the conditions or not. For this purpose, Singapore has appointed or is in the process of appointing more than 100 assessors. These assessors will determine the claim of the party. This assessor's determination is final and non-appealable. If the assessors find that the claim is valid, then it will declare so. And over and above such declaration, the assessor is given the power to issue such further directions as it may be equitably necessary to do. It means that the assessors have the power to balance the equities between a party which complains of hardship and the other party which contests such claim. The Act, most importantly, highlights that this is a temporary relief granted excuse me, on account of the pandemic, and does not provide a substantive defense to liability. The Act is for a specified duration, and upon the expiry of such duration, Singapore government will take a call as to whether such period should be extended or not. The whole Singapore legislation is, in my view, a very effective response to the current crisis. All those commercial tenancies in our big cities like Delhi, Bombay, Chennai, Kolkata, Bangalore, Ahmedabad, and many other cities which are growing fast. All these cities and the commercial communities trading there are currently suffering this problem. Their contracts have run into severe stress. Let India follow this Singapore model and enact some kind of a legislation for the purpose of providing a temporary relief. As of now, instead of providing the two extremes of either upholding the contract in full and enforcing it in its full rigor, and on the other extreme, killing the contract by voiding it, in the middle of these two, there is a mechanism to suspend the operation of the contract for the period of pandemic, for balancing the equities between the two parties during this period. And once, God willing, the pandemic is over soon, and the return of the normalcy, the parties can be relegated back to their contractual freedom, autonomy, and position. The current times are extraordinary times. They require extraordinary measures. Now from Singapore, friends, let us go to Australia. Australia has a federal government and as well as there are various states. The federal government has come out with a code of practice for commercial tenancies. And the state governments are given the freedom to determine when they will apply this code to their respective states. There are regulations enacted under this code. We are, of course, not concerned with the niceties and the nitty-gritties of such code. They are not helpful to us. I wish to tell you about the central idea behind this code. What the code does is to issue a mandatory directions to the parties, both landlords and tenants, to begin mediation, to begin negotiations for alleviating their hardship. Such negotiations are directed to be focused on the waiver of the rent and the deferral of the rent. And the code has prescribed that the rent must be sizably reduced, beginning with 50% or more, and appropriate waivers are also required to be negotiated. The Act further provides that if these negotiations fail, then the parties must be compulsorily referred to mediators, and the mediators will take the decision. Just like the Singapore law, this Act also makes it clear that this is a very temporary relief. It does not afford a substantive defense to contractual liability. That is not sought to be disturbed, but it gives relief. Neither the landlords want that the tenancy must come to an end, nor the tenants want that in all cases the tenancy must come to an end. Therefore, this is a time when there are types of contracts which require, if I can use the medical term, nursing. The contracts have become sick. The contracts are also hit by pandemic. This contract require nursing, temporary reliefs till the return of the normalcy. And the Australian code provides a mechanism for nursing the contracts. They provide the directions to negotiate, they provide the appointment of the mediators, and they provide for, most importantly, waiver of rent, reduction of rent, stopping the right of recovery of possession or forfeiture, and prevention of encashment of any kind of security or bank guarantee or the like. Again, the Australian legislation is also not restricted to commercial tenancies. Although I referred to the code, but Australia has enacted various other measures applicable to various types of contracts with more or less similar reliefs. Therefore, if we can see that India has in the past provided for statutory intervention in the performance of the contracts, like the SICA and the Bombay Relief Undertaking Acts. there is no reason why a similar legislation cannot be enacted, maybe by way of a route of ordinance, because the parliament and the legislatures are not in session to provide an effective relief to the commercial community. The RBI moratorium is only applicable to banks and financial institutions. It doesn't apply to private contracts between the parties. It does not even apply to the private finances, which are not infrequent in our commercial community. Therefore, there is a strong need for an intervention by the parliament or the state legislatures to alleviate the hardship to the people in India. Now, from Singapore and Australia, we go to the extraordinary legislation enacted by the United Kingdom. It is called Coronavirus Act 2020. The relevant sections in the context of commercial tenancies and residential tenancies are sections 81 and 82. They provide for more or less the same reliefs. No forfeiture or eviction because of non-payment of rent. No enforcement of other penal provisions. The reliefs and the moratoriums in the payment of rent. There are various other contracts also, which this Coronavirus Act 2020 deals with. In fact, this is the most exhaustive piece of legislation that I have come across amongst the various countries. The whole act runs into more than 300 pages. It deals with various situations besides contracts, and I would suggest that it would be worthwhile to spend some time on the study of this act as to how immediate and prompt legislative response to the current crisis is provided by the legislatures of the world. Friends, now having seen what the world has done, let us come back to India. Our country is facing the crisis on an unprecedented scale. Probably such scale is not existent in the smaller countries, and that allows them to move effective legislations at great speed. But if there is no legislation in India or the states of India coming in the near future, I have my firm hope in our judiciary. Our Supreme Court and our High Courts, with their glorious tradition of judicial legislation in absence of legislation from the Parliament and the state legislatures. The instances abound when the Supreme Court and the High Courts have intervened to alleviate the hardship of the people. If we study only Article 21 of the Constitution of India, how the right to life has been expanded to cover so many areas which were probably not in the contemplation of the Constitution makers. Similarly, in the issues arising from environmental pollution or custodial torture or human rights, and in last 2 or 3 years, our Supreme Court has entered a liberal phase where the right to privacy has been recognized, euthanasia has been recognized. All these steps have been taken by the Supreme Court in absence of a legislation. The other instances of the Admiralty jurisdiction of the high courts. That famous judgment of Elizabeth in 1993 is a classic instance of judicial legislation. In fact, I was reading a keynote address by Justice Kurian Joseph, a former judge of the Supreme Court, which is reported in 2016 Volume 2 Supreme Court Cases, Journal section, page 18. I will repeat, 2016 Volume 2 Supreme Court Cases, Journal section, page 18. Justice Kurian Joseph has delivered a very informative and insightful lecture about the judicial legislation by the superior courts. Therefore, a public interest litigation may be invoking Article 142 of the Supreme Court, requesting for an urgent relief can be considered. The Supreme Court can be requested to grant temporary relief with a direction to the central government to come out with an ordinance within a reasonable time. Such course of action is required to be considered for the benefit of the community. If it brings a serious burden on the judiciary, if the commercial community rushes to the court, if it opens the floodgates, if that is the fear, it is also possible to resort to an Australian model by providing either a compulsory mediation or a compulsory arbitration. There are many agreements which contain arbitration clause, but by law it is possible to include an arbitration clause in all contracts, regardless of whether the parties have provided arbitration agreement or not. Even those agreements with no arbitration clauses can suffer a compulsory statutory induction of an arbitration clause to alleviate the burden on the courts. If our legal infrastructure is to be saved from the floodgates, let us have compulsory arbitration. We have a battery of retired judges, both at the High Court and the district judges level, in good health and able to deliver justice in short time. We all have to come together and evolve a prompt response to come to the help of the commercial community. And I am not focusing only on the commercial community with showrooms and offices. There must be countless residential tenants who must be suffering hardship. The tenants who are unable to pay the rent, the landlords who might have taken loan to acquire the premises are unable to pay the installments to the financiers, maybe private financiers. Therefore, these kind of measures are required to be taken on a top priority basis. We have to approach the courts for the purpose of exercising the rights to temporarily suspend the enforcement of the contracts. In this connection, I want to refer you to a concept which is now developed in the common law in United Kingdom, and it is heavily influenced by a continental development, which is called the abuse of contractual rights. If you will research on this topic, you will find in last 15-20 years, there are numerous judgments dealing with this problem of abuse of contractual rights. There comes moment in the life of the contract when the exercise of the right would become an abuse of right. It will become inequitable to allow the parties to enforce their rights in the current situation. Therefore, resorting to the equitable jurisdiction of our courts, resting in the High Court, resting in the lower courts, not confined to the four corners of the Specific Relief Act, but invoking the wider equity jurisdiction and invoking the principles of justice, equity, and good conscience. Without the legislative intervention, the parties can approach the courts with a request that in view of these extraordinary circumstances and the financial hardship which it has brought, please do not enforce my contract. Please halt temporarily the enforcement of the contract. Therefore, to come back to my familiar topic and the thesis of this whole today's webinar, that instead of choosing the two extremes of either killing the contract or enforcing the contract as it originally stood, let us evolve an appropriate judicial response, absent legislation, to deal with this situation and come to the rescue of the people at large, including the commercial community. Let equity come to the aid of the law and intervene and stop the enforcement of the contract. Surely the courts have the power to say no to the Shylocks. Let the courts rise to the occasion and equitably intervene in the performance of the contracts. Such equitable intervention may take place of completely suspending the contract, or maybe altering the terms of the contract, modifying the terms of the contract, adjusting the equities between both the parties, and by declaring that the same is purely a temporary measure and not a complete substitution or a novation of the contract. Without sacrificing the autonomy of the parties and the freedom of contracts, the courts can provide an effective means of equitable intervention in the performance of the contract on a temporary basis. I would look forward to the day when hopefully somebody files a public interest litigation in the Supreme Court and requests that appropriate directions may be issued. Until then, on the lines of either the Singapore, Australia, or UK legislations, some kind of temporary measures may be enacted for the purpose of helping our people. Thank you very much. I can take questions if you like.
The participants are requested to kindly send me a message. I will unmute the participants one at a time for their questions.
Shashwat, do you think anything is left out? No, you can tell me. It covers broadly what I wanted to say. Doesn't matter. I'm conscious that it is on.
Jaini, your mic is open. You can ask a question.
Yeah, there is a question from Jaini. Yes, go ahead.
Sir, when you talk about factors, what factors will you take into consideration when deciding whether actual hardships are taken into consideration?
For example, and not trying to be exhaustive, as you will appreciate it is not possible. Suppose if a commercial premises is not able to operate for, say, 3 months, God forbid the lockdown is required to be extended, say, for 3 months. So that shop has not done any business for 3 months at all. And if the tenant is asked to pay the rent, then the whole rent for the period of 3 months can be either suspended as a temporary measure or reduced by an equitable percentage as may be deemed fit by the court. Therefore, the court can either waive the rent partially or provide a deferral. The court can grant installments. In fact, I forgot to mention that in one of the legislations, either Singapore or Australia, there is a provision that the deferred rent will not be payable at once after the lockdown is lifted or the pandemic is over, but it would be spread over the entire duration of the tenancy. In other words, kind of granting installments. This power is exercised by our courts when the decree is passed under Order 21. So such power can be exercised.
Understood. Thank you.
The next question is from Asit Bhai Joshi. Asit Bhai, please go ahead.
Sir, what will happen to the autonomy, will and freedom of the parties to the contract if arbitration clause is made compulsory? Because every citizen has a right to claim justice through court.
Yes, I agree. But if the courts are flooded with work of such nature, and if they are not able to provide the temporary relief immediately, then as a measure of emergency, arbitration can be compulsorily provided. You may be familiar with certain labor laws where compulsory arbitration is there. You are also aware of the construction contracts with the government where there is a statutory tribunal which is kind of a substitute for arbitration. So the idea of a compulsory arbitration is not entirely foreign to our system, and to an extent it impinges on the autonomy, but I believe that is the need of the hour. Otherwise our courts will not be able to cope up with this.
The next question is from Aditya Dave. Aditya, please go ahead.
Yes, good morning, sir. So my question is, what will happen for most of the contracts where time is the essence of that contract? Because what those models have worked out in respect to these kinds of contracts? Because that will be very difficult to enforce then.
In such contracts also, temporary relief is required to be granted, and to that extent it will modify the contract. Even if time is of the essence of the contract, but if the defaulting party is prevented from performing on account of this pandemic, then it would be very inequitable to enforce the clause which says that the time is of the essence of the contract.
Okay, sir. Thank you.
Yes.
The next question is from MJT.
I have a query.
Good morning, Vijay.
Yes, I have constructed a flat, taking substantial 70% loan, and I have given all the flats on lease at a particular rate. If lease rents are reduced, what would happen to my loan?
RBI has already provided the moratorium.
It has only provided a moratorium of non-payment, not discharge.
Even this rent payment also is only deferral and not a defense to the liability.
So
The liability,
unless the liability is discharged, the burden will remain whether today or tomorrow. And
certainly.
can the act be enacted to discharge or reduce the liability? That will be disastrous consequences down the line. Banks will be in difficulty.
None of the foreign legislations
They have not done it. They have not done it. I know
they
that.
have not done
Singapore
it.
and England, I have checked it. But if we do that of relief, it will be disastrous.
No, I am not advocating a complete discharge. I said instead of killing the contract, temporarily suspend its enforcement. We all know Mirbai section 22 of the SICA. The performance of the contract was suspended in respect of the companies whose wealth and position was such that it commanded the attention of the lawmakers. The current problem is faced by much smaller people, smaller in economic scale, whose hardship, if it is not commanding the attention of the lawmakers, I believe let courts take the road forward and evolve some kind of a formula. The whole exercise is for suspension of the contract and not killing it.
Suspension without discharge of liability even during this 3 months period.
I entirely agree. There is no need to discharge the liability. But having said that, I just want to raise an issue that in appropriate cases, even liability can be discharged also. Let me give you an instance. We are all familiar with the legislations providing relief to the agricultural debts. From time to time, our parliaments and legislatures have enacted laws to completely waive off the loans given to agriculturists. Now that also in a way interferes with the autonomy of the contract.
Undisputedly, it interferes, and it also affects badly the banking system of the country.
Yes.
Now, if such discharges are given on a whole hog basis of liability to the bank, it will create a havoc and the banks will be in serious difficulties.
I completely take the point. The question is that for not giving the discharge, whether we should not also give temporary reliefs.
Temporary, no issues. Temporary, no issues. I am on discharge only.
But on the point of discharge, I am saying that instead of taking a view that discharge should never be granted, is it not possible to evolve a kind of a mechanism where at least the superior courts have a power to give the discharge? And then the question would be between never and hardly ever. In most of the cases, don't give discharge. But why deprive our superior courts of the power to give the discharge if an appropriate case commends for it? Would you agree?
A little difficult to agree only on this count because it will depend upon the chancellor's foot.
Yes, it would.
That's the only reason.
Yes.
And so much discretion cannot be given to any judge.
But then it is all subject to the checks and balances of appeals and right up to the Supreme Court. The question which I feel, Mirbai, is acute is of the residential tenants in big cities where the employees are not getting their salaries and where the landlords are breathing on their neck for payment of rent. And most of the landlords are to some extent investors. Yes, and I am not saying therefore that equities should not be balanced. In fact, if you would have noticed, there is a provision in the Singapore legislation that the assessor has a power to order further measures. And those further measures may include some payment to be made to the landlords from time to time. That I have seen.
Yes.
So, balancing equities without discharging liability, this is a need of the hour that some temporary suspension of contractual rights
undisputedly on that.
Yeah,
I am only worried of the whole economy system, the whole system of the economy. That's what is worrying me.
I completely share your anxieties, and I am not advocating a total discharge of liability.
Fine.
I am only saying, let this situation let it cool down until then some temporary enforcement, suspension of enforcement.
Fine. I think others may want some questions. That's fine.
Thank you, Mirvi.
The next question is from Panthil Bhai.
Yes, sir. I would like to ask a question that whether frustration of a contract can be implied, can it be implied in a contract?
Yes, there I want to slightly discuss and elaborate the law, because there are conflicting views on this which we must examine. One view is that when the parties provide for a force majeure clause in the contract, it excludes the doctrine of frustration under common law. But the other view is that the clause does not exclude the doctrine of frustration, and when circumstances arise which are not covered by that clause, parties can always resort to the doctrine of frustration. So my personal view is that the later view is correct. The parties may assess the risk at the time of entering into contract and have clauses to take care of their possible risks. But if this is not exhaustive, then parties must be allowed to resort to law. And I believe that Section 56 of the Contract Act is in absolute terms. It doesn't say subject to the contract, to the contrary. Therefore, we can always resort to Section 56, even when we find that the force majeure clause in the agreement is not adequate to take care of the situation.
Thank you, sir.
The next question is from Mr. Bhavesh Kansara.
Hello.
Yes.
Am I audible, sir?
Yes.
Good afternoon, sir. This is Bhavesh. And I just wanted to ask if the judiciary is allowed to pass any legislation, and both the litigants, the tenant as well as the landlord. Now, if the landlord claims that he is surviving on the rental income, then what happens?
Yes. Yes, if the landlord is surviving on the rental income, then he can plead his hardship to the court, and that will be taken into account. When I speak of... Sorry, let me finish, Bhavesh. Let me finish. Yeah. I hope that it will give you the answer. When I say that suspend the payment of rent, it can also mean a partial suspension. Suppose rent is 100 rupees, court can say don't pay 100 rupees, but pay only 50 rupees. So the landlord's needs are also partially taken care of. So when I'm talking of suspension, I'm not talking of extremes. And that is the purpose of this whole exercise, that instead of going to extremes, let us navigate the middle course.
I understand, sir. So the entire thing boils down to negotiation between the two parties?
No, if the negotiations fail, I advocate that the courts must exercise the power of equitable redistribution of the burdens of contract.
Okay, sir. Thank you very much.
Thank you.
The next question is from Amrita Patel.
Yes.
Go ahead, Amrita.
I can't hear her.
Okay.
If there is any other question, Aaron, we can take that
Okay.
question.
Vrudang Parik.
Yes, sir. Good afternoon, sir. Yes, sir.
Good afternoon.
Sir, does the clause of force majeure will require separate mention of pandemic in the future agreements, and if the clause of force majeure is applied, then won't it lead to too much litigations in the current scenario, sir?
Yes, but if there is hardship, there is bound to be litigation. And we have to devise the system which must take on all the litigations which come to it. Because very few parties litigate for pleasure. They litigate because of compulsion. And the system must have the adequate resources to respond to their problems and solve them. So we cannot, under the fear of the floodgates, stop the parties from coming to courts.
Right. Thank you so much, sir.
So the next question is from Amrita Patel. She has been logged out, unfortunately, but her questions are: why should the
Yes.
pandemic be treated any differently from any other natural calamity requiring such measures? And how will the autonomy of parties be preserved, since the concept of equity will be highly subjective?
So she has asked two questions.
Yes, sir.
What was the first question? Would you repeat?
Yes. Her first question was, why should the pandemic be treated any differently from any other natural calamity
The
requiring such...
answer to the question is simple. This pandemic is on a completely different scale. That makes it totally different from natural calamities. They are localized and not so widespread. The second question?
How will the autonomy of parties be preserved, since the concept of equity will be highly subjective?
In all situations, the autonomy is not required to be preserved. It is a question of choosing values. The current crisis shows that the value of equitable intervention, diluting the party's autonomy and freedom of contract, is the need of the hour.
That's it, sir. We are done with
I
our...
hope these answers reach her.
Hopefully.
So there are no more questions, right?
No, sir.
All right. Thank you very much for all who have joined in this exercise. Wish you very safe and comfortable lockdown. That we recover our normal position. I once again end with that famous Sanskrit saying, Ano Bhadraha Kratavo Yantu Vishwataha. Let the best thoughts from the whole world come to us. And with this hope, and with the hope that India will follow the models established by Singapore, Australia, and United Kingdom, with whatever modifications which we consider necessary, and help the commercial community. Thank you very much.
Thank you, sir.